Hello, my name is Victoria Passmore, and I will be discussing two different cases for my case study analysis. So let's jump right in. The first case I will discuss is the New York Times versus Sullivan case. This case is categorized as a defamation case. The plaintiff, Sullivan, is suing the defendant, the New York Times, for defamation due to a printed advertisement about the civil rights movement in the South. The full-page advertisement that was printed by the New York Times on March 29, 1960, was entitled, "Heed Their Rising Voices." The ad implied there was an unparalleled wave of terror that had been focused towards those who participated in the civil rights movement in the South. The ad alleged the arrest of Dr. Martin Luther King Jr. for perjury in Alabama was a part of a campaign to demolish King's efforts to combine public facilities and urge blacks to vote. L.B. Sullivan, the Montgomery City Commissioner, filed a libel action against the newspaper and four black ministers who were listed as endorsers of the ad, claiming that the allegations against the Montgomery police defamed him personally. The article did not mention Sullivan by name, but he felt it indirectly addressed him due to his position with the police department. The defendant felt that the ad was okay to print because they had no reason to believe contents were false. Sullivan felt his reputation was damaged by the New York Times, mainly due to a civil rights movement advertisement that was published. Although the advertisement makes no personal attacks to any individual, including Sullivan, he felt attacked indirectly because of his involvement with the police department. The references to the police really hit close to home for Sullivan because he was the commissioner who had jurisdiction over the police, so he felt he was being indirectly attacked. The elements of libel under Alabama law states a publication is found liable if the content is used to hurt the person's reputation, and the injury must find the content to be about the plaintiff. Once libel, it is established, the defendant must prove that the facts stated are indeed true. The plaintiff, Sullivan, had to prove there was actual malice intent when the New York Times published the advertisement. In order for malice to be proved, the plaintiff must show evidence that the New York Times intended to damage his reputation. If malice is not proved, it can unconstitutionally infringe the First Amendment's freedom of speech and freedom of press protections. So concluding, the jury found no proof of malice and awarded the plaintiff $500,000 in damages under Alabama law. Sullivan did not have to prove that he had been harmed, and a defense claiming that the ad was truthful was unavailable since the ad contained factual errors. The defendant appealed this case. The next case we had to cover was Gertz versus Welch. This case involved Gertz, an attorney who is suing Welch, a magazine publisher, for the American Opinion. The plaintiff is a private person and is not a public figure, so in this case, Gertz has the right to recover for actual damages if defamatory statements are found to be true. Gertz won a jury verdict and an award of $50,000 but lost his libel suit because the trial judge found that the magazine had not violated the actual malice test for libel, which the Supreme Court had established in New York Times versus Sullivan in 1964. Allegedly, the American Opinion sought after the reputation of Gertz by publishing false statements about his character. Gertz was an attorney who was hired by the family of a victim who was murdered by a Chicago officer. The American Opinion accused Gertz of being a Leninist and a communist fronter because he chose to represent clients who were suing a law enforcement officer. In the article, it was implied that Gertz had a criminal record, but this statement was not verified. Gertz was a private figure and would need to prove only negligence, a jury's opinion of what a liable defendant should not have done, instead of the more rigorous standard of proof of actual malice. Actual malice requires proof of knowing falsity or reckless disregard for the truth on the part of the publisher. Private individuals do not have the same access to channels of communication as a public official or figure, and therefore they have a more genuine ability to defend themselves in a controversy. Although Gertz was not a public figure, his reputation was in a way affected by the article published by the American Opinion. The article portrayed him to be a criminal and someone who was involved in a communist group. The issue with the statements was that there was no real evidence Mr. Gertz was a communist or a Leninist, as the article claimed, nor was there evidence of a criminal record. The managing editor of American Opinion did not confirm if the writer's accusations were indeed true. In order to avoid a lawsuit, Welch should have verified the contents being written about Gertz were true before publishing the article. The managing editor did not double-check the work of the writer because he has known him to be factual, but the editor should not have assumed and instead verified for himself. The article could have also been written without using statements that made Gertz feel attacked. I believe in freedom of speech, but if the statements made are not factual and are biased, it can cause a problem. Even though Gertz lost the libel suit, the best thing Welch could have done was verified all information pertaining to Gertz before it was published. My state, which is Illinois' defamation law, is quite similar to the elements listed in the general defamation law. Under Illinois law, the components of a defamation claim are: the defendant made a false statement about the plaintiff, there was an unprivileged publication to a third party, fault by the defendant amounting to at least negligence, and the publication damaged the plaintiff. The statute of limitations in Illinois are for 1 year. Illinois also acknowledges certain statements qualifying as defamation per se: accuses the plaintiff of committing a crime, indicates the plaintiff is infected with a loathsome communicable disease, indicates that the plaintiff is unable to perform or lacks integrity in performing his or her employment duties, attributes to the plaintiff a lack of ability or otherwise harms the plaintiff in his or her profession, or accuses the plaintiff of engaging in adultery or fornication. My thoughts on everything. After reviewing both the Sullivan and Gertz cases, I have learned a great deal of information that will help me with my future work in the communications industry. Understanding how to read cases and the different laws that support the cases are important to understand in the industry. It is important to make sure any information that is published is factual, because you never know when a person may file a defamation suit against you or the company you work for. So it's best to just be safe. Here are my references for my case study. Thank you so much for listening. I hope you enjoyed. Have a nice day.